This is brought to you by Cook County's Commission on Human Rights. The purpose of this video is to describe what an individualized assessment is and how it is used in association with the Just Housing Amendment of the Cook County Human Rights Ordinance. On April 25, 2019, the Cook County Board of Commissioners passed the Just Housing Amendment to the Cook County Human Rights Ordinance to prohibit housing discrimination based on an individual's covered criminal history and require landlords considering an individual's covered criminal history to perform an individualized assessment of an otherwise qualified individual's criminal conviction history prior to denying them any application for housing. The Just Housing Amendment went into effect on January 1, 2020, with initial enforcement on February 1, 2020. The Just Housing Amendment includes several newer procedures for housing providers and seekers to be aware of and practice. The Cook County Commission on Human Rights wants to ensure that the public understands these procedures as clearly as possible. We are going to walk through some of these procedures together. In compliance with the Just Housing Amendment, there are new or different requirements for processing housing applications. One such requirement is an individualized assessment of the results of the 3-year lookback period of a criminal background check. The individualized assessment is an evaluation tool to use after the landlord has completed a criminal background check and given the applicant the opportunity to dispute inaccuracies in the background check. This tool will help determine if criminal history within the 3-year lookback period negatively impacts the applicant's ability to fulfill the responsibilities of tenancy. The individualized assessment should determine if the applicant poses a demonstrable risk to other residents or property. Demonstrable risk refers to the likelihood of harm to other residents, personal safety, and/or likelihood of serious damage to property. It is important to note that this questionnaire is not an all-inclusive instrument and should not be taken as such. All answers to questions within an individualized assessment should be documented for possible future reference. Factors that may be considered in performing the individualized assessment include, but are not limited to, the nature and severity of the criminal offense and how recently it occurred, the nature of the sentencing, the number of the applicant's criminal convictions, the length of time that has passed since the applicant's most recent conviction, the age of the individual at the time the criminal offense occurred, evidence of rehabilitation, the individual history as a tenant before and/or after the conviction, whether the criminal conviction or convictions was related to or a product of the applicant's disability, and if the applicant is a person with a disability, whether any reasonable accommodation could be provided to reduce any alleged demonstrable risk. Each of these can be represented by questions such as the examples listed on the screen. It is important to also ask, are there any other additional relevant factors that I should consider? The individualized assessment should reveal more context regarding the circumstances of the applicant's justice involvement. Based upon the individualized assessment, the landlord must notify the applicant of an approval or denial of the housing application. If you have any questions or believe that a landlord or housing provider violated the Just Housing Amendment, contact the Cook County Commission on Human Rights. If you're a landlord or housing provider in Cook County and are looking for clarification, please contact us. We recommend you learn more on our website at bit.ly/HR Commission, and more specifically about the Just Housing Amendment at bit.ly/Just Housing Amendment. Our email address is human.rights@cookcountyil.gov, and our phone number is 312-603-1100. This does not constitute legal advice and is for educational purposes only.